Hello, if you're tired of claims from a bailiff, if you're somehow involved in legal proceedings, then I recommend listening to our conversation today regarding aspects of litigation and the consequences of litigation and enforcement proceedings with a lawyer from our firm, Anna Berest.
Hello, Vladimir.
A lot of people have reached out to us recently, calling in to ask how bailiffs will do this or that. There are so many such cases, and honestly, we don't always take them on. Can I ask you a few specific questions regarding this whole process of judicial enforcement? In general, could you tell our viewers when does it actually begin and how does it really happen, this judicial enforcement process?
Judicial enforcement proceedings begin the moment a court decision takes legal effect. When the debtor fails to voluntarily comply with the ruling, the creditor, the claimant, has the right to apply to a bailiff. You must provide them with the necessary enforcement document, which will be either the court decision itself or another legally recognized document.
So he physically takes the court decision, goes to his office, or does he write online?
This can be done, of course, digitally by sending an application, sending a court decision, or another enforcement document. And in enforcement proceedings, the principle of formalization applies, the bailiff receives the application, and the enforcement proceedings begin.
And how to understand that it has started, this judicial proceeding? Because we've encountered such documents where the bailiff says, comply within so many days and you'll literally be happy. You won't pay so much money, but if you don't, then you'll already have to pay so much money. Is this already considered that judicial enforcement has been initiated or not yet?
Yes, it's considered from the moment the enforcement proceedings are opened, the enforcement proceedings have begun, and the legal obligation is as follows. The bailiff must serve the enforcement documents, notices of the start of enforcement proceedings to the debtor. He chooses the method of service himself. That is, it's standard now that notice is sent to the debtor at a known email address.
And if it doesn't work?
If that approach doesn't work, and for example, the debtor does not reside at the address listed in the population register, and the bailiff has no other way to locate them, then in Estonia there is an alternative method of service available. It is known as ametlikud teadaanded, which is the official public notice system used here in Estonia.
The Gazette.
This is a gazette that publishes the formal notice regarding the commencement of judicial enforcement proceedings in this gazette, and this notification is provided accordingly for the benefit of the debtor.
The deadline for compliance, the debtor received notice that enforcement proceedings have been initiated against them. What should he do when he receives the notice?
The next step, what he should do, is first of all not to panic, not to try to hide, because the most effective way is to establish communication with the bailiff. It is possible to set up a payment schedule. This depends, of course, on the creditor. The bailiff is essentially just a mediator.
I see. So if the creditor doesn't agree, what's next?
The law provides you with the option to apply to the court for an installment plan. And then the court will make a decision based on the opinions of the creditor, the debtor, and the bailiff involved in the case.
What does that mean? So if enforcement is underway and the creditor hasn't agreed to installments, the debtor can go to court?
Yes, they have the right to apply to the court, to present their case, how long they need for installments, what circumstances are involved, why they can't pay the full amount at once, right? And usually, if there are clear objective circumstances, the court will rule in favor of the debtor. A formal court order for a repayment schedule is then issued, and as long as that schedule is followed by the debtor, then that is essentially it. The debt is paid according to the schedule, and as a result, the enforcement proceedings are closed.
Okay, and if things didn't work out as planned, or if the person didn't apply to the court for an installment plan, what exactly will they be facing in the next stage?
The next stage of the process will be the seizure of property.
If there is any.
If there is any, yes, and the seizure of income that is allowed under Estonian law. So the debtor must understand that it is their responsibility to actively communicate with the bailiff. They need to tell them where to leave funds, specifically in which bank account, and ensure they leave the subsistence minimum, especially if they have dependents. All these factors are very important because they directly affect the amount of money they can use every month that will not be subject to seizure.
So the bailiff can't just take everything?
No, they cannot take absolutely everything.
And what about, for example, an apartment? Say a debtor lives there with a whole family, children, and they owe 50,000 euros to some creditor or a failed business or something else. They have to pay it back, or they were scammed and have to settle with the bank. What should they do in such a situation?
In such a difficult situation, if a mortgage is actively being enforced and the debtor simply cannot pay back the loan that the mortgage secures, then the bank has no choice but to turn to the bailiff. At that point, formal enforcement proceedings begin, and here there can be no talk of a payment schedule anymore, because it is specifically a mortgage claim that is being enforced, which leaves very little room for any further negotiation.
And if there's no mortgage involved, if, say, it's a certain third-party creditor not connected to a bank, but there's simply an outstanding debt and the debtor has an asset like a residential apartment, for instance.
Yes, a court bailiff can seize the apartment, right? Is provided for.
Stop property seizure.
Preventing the seizure is something the debtor is simply not allowed to do.
And if the apartment is for two, for three?
If the owner is not only the debtor, but there is also, for example, the apartment is held in joint ownership, right?
Right?
Then in such a case, the bailiff cannot seize the apartment, but the creditor has the opportunity to file a lawsuit in court and divide the joint property, and only then, accordingly, the bailiff will be able to seize the share that will belong to the debtor after the division of the joint property.
So this is another process?
Furthermore, this represents an additional process that the creditor can choose to formally initiate at their own request. That is, it is not the bailiff who initiates this process, but the creditor. And when the court makes a decision on the division of joint property, then it is seized.
So judicial enforcement is like an avalanche. It's practically impossible to stop. Or are there still some mechanisms, procedures that can slow down judicial enforcement or even declare it illegal or in some other way make life easier for the debtor?
As I have already repeated, if the debtor understands that, according to the payment schedule, they still have a real opportunity to pay off this debt.
There is no schedule. It simply didn't happen.
If we are saying that the schedule didn't happen, but for some reasons, the debtor believes that the enforcement proceedings are illegal, invalid. Maybe they had a prior agreement, for example, on an installment plan with the creditor, or they believe that they have paid off this debt, or other circumstances have appeared that were absent at the time of the ruling, or were unknown to the debtor at the time the court decision was made. In such a case, the debtor has the right to apply to the court with a claim to declare the enforcement proceedings invalid.
So, in other words, if the decision has entered into legal force and after that something came to light, then this is a prerequisite for going to court to declare the judicial enforcement invalid.
Yes, the enforcement proceedings invalid.
Good. And what could that be? For example, let's say you mentioned that some agreement took place between them or they paid something before that. How does it look in practice?
In practice, it looks something like this. For example, let us say a debtor had several different loan agreements, right? And then when they were making a payment, they accidentally specified the wrong reference number or perhaps the wrong agreement number entirely. Naturally, the payment went through. It was processed in the creditor's accounting department.
A formal error.
A formal error.
In essence, he has fulfilled these obligations of his.
Yes. He believes that he has fulfilled them. He believes that it was specifically for this loan obligation that he made this payment.
Essentially, this does not affect the decision, that does not
affect it in any way. The established law and current judicial practice clearly provide that this is by no means a new review of the case. The situation is not that at all. Rather, it specifically concerns new circumstances that only came to light after the court decision had already come into force and which were either entirely unknown or simply absent at the time of the legal process when that initial court decision was made.
There's also this thing, an auction, when property is seized and put up for sale. It's a very painful topic for many debtors who unfortunately have had this negative experience. How should one act in this situation?
After the seizure, naturally, the next step is putting the property up for public auction, yes. Here, it's important, and I'll say it again, to communicate with the bailiff because the bailiff will send, and he has an obligation to deliver the auction notice in one way or another, whether it's by email or by courier, or as we already mentioned, it's
notified, let's say they notified the debtor.
The debtor really shouldn't obstruct the bailiff, for example, from coming over and taking photos of the property. This is important because that process will help increase the property's overall value, and consequently the debt will be covered more effectively. Everything that remains after the debt is fully paid off will be returned to the debtor, and the debtor will be able to somehow move on with their life thanks to that. So if the debtor completely refuses to cooperate, right, and obstructs the bailiff, for example, from showing the apartment to interested buyers or taking photos, then the bailiff has the right to go to court and obtain an order. And so which will allow the bailiff, in the presence of the police, to forcibly enter.
Police will involve the... I understand. This is an endless topic. We could talk for days on this subject. I'd like to ask, are there any time limits in enforcement proceedings?
Yes, that too. This is also an important aspect that you need to understand. That is, court decisions can be under enforcement for 10 years. After this period expires, the debtor has the right to apply to the bailiff with a request to recognize the enforcement proceedings. That is, that the term of the enforcement proceedings, it turns out, has expired as established by law, right? And then, once the entire process is complete, the bailiff officially terminates the actual collection of the debt, right? However, the debtor still maintains a clear legal obligation to pay at least half of the bailiff's fee. Because of this action alone won't be enough to completely close out the enforcement proceedings. Would you agree? But at least it will remove the debt, the main debt obligation.
The person no longer has the debt.
None.
If, say, within 10 years they couldn't claim the debt, then after 10 years this right, the creditor, as it were, loses this right?
Loses it, yes.
The debtor can refuse enforcement but must pay half the bailiff's costs.
Yes. All of this is through an application to the bailiff. So you have to go through this procedure. It's not simple.
How would you evaluate it yourself? Given your extensive experience in this enforcement, how effectively does this procedure work in Estonia?
I would say that if the creditor has a genuine interest in collecting the debt as quickly as possible, and the creditor also maintains active, consistent communication with the bailiff, then in that case things should move along much faster. This process will be both fast and effective, and the debt will be recovered. If the debtor truly has some resources, which means assets, or some income that can be seized, then the debt can be collected accordingly. So
What recommendations would you give to people who find themselves in this situation, who are involved in enforcement proceedings on either side? Well, for instance, you mentioned that one shouldn't ignore the requirements of the bailiff. What else, let's say, along those lines?
I would still strongly advise looking for a practical way to reach a mutual agreement, because in the long run, that is by far the most painless way to settle this matter. In my professional experience, I have found that if a debtor immediately applies for a structured payment schedule, then very often the creditors are willing to cooperate. If the debtor truly has a genuine ability to follow the proposed repayment schedule, then everything should go quite smoothly. This is a major advantage because you can even petition the court to ensure your income and bank accounts are not frozen during the process, which really helps keep things stable, you see.
We were talking about court decisions arising from civil proceedings, but what if there are, for example, some fines, or if there are some other, well, let's say matters related to fines? What about the deadlines for enforcement regarding those?
Yes, if it's a public claim like fines, meaning for a civil claim, the voluntary compliance period is 30 days. But if it's a public claim being enforced, like a fine or another claim, then the period is very short. It's 10 days. Within 10 days, you must voluntarily comply with it.
All right. And how long will the enforcement proceedings themselves last regarding a fine?
Regarding fines, the enforcement proceedings will last for 3 years. And it is really important to fully understand that if the total fine amount happens to be over 400 euros, then after a period of 1 year, if absolutely no payment has been made, the bailiff is then legally granted the right to file a formal notice to proceed with the collection to the public body, that is responsible for collecting that fine. And the public body then has the right to go to court report that payment isn't happening, and the court can then replace the fine with either detention or some kind of community service. So the debtor should also fully understand that this particular danger does indeed exist.
So there is a danger.
There is a danger.
On that positive note, thank you so much for explaining this to us. Thank you very much.